Namaskar, welcome to India First. Tonight we'll be discussing the advantages that India has as a potential hub for alternative dispute resolution, especially arbitration. Yesterday, Prime Minister Narendra Modi underlined the necessity to facilitate a vibrant ecosystem for alternative dispute resolution during his valedictory address to the first ever global conference on arbitration. Let's listen.
We need to simultaneously facilitate a vibrant ecosystem for alternate dispute resolution, including arbitration, mediation, and conciliation. Creation of a vibrant ecosystem for institutional arbitration is one of the foremost priorities of our government. And enabling alternate dispute resolution ecosystem is a national priority for India. We need to promote India globally as an arbitration hub.
Well, the Prime Minister said that India is experiencing a digital revolution which has increased the number of business models also.
India is experiencing a digital revolution. This is bridging the digital and economic divide in Indian society in general and rural society in particular. A boost to the rural economy through this revolution will make the Indian economy even more robust. Innovation-based startups have instilled a spirit of enterprise among Indians. Yesterday's job seekers are becoming today's job creators.
And the Union of India says that not that voice in the international system, voice of international source and trade government and working and the government is working towards making a place for India in this system.
India is an emerging economy, a good part of the world. But how many arbitrators of Indian origin or Asian origin we see or international arbitration ecosystem? We all have respect for Queen Counsel barristers, but why is it that they are treated as the only embodiment of arbitral knowledge, hopping from one arbitration to other? These are issues which will have to be reflected upon. And yes, the international arbitration ecosystem need to recognize that today the world is changing, Asia is emerging, India is emerging, many other countries across the board are emerging, and they need to find a voice in the entire international arbitration ecosystem.
And the Chief Justice of India, T.S. Thakur, pitched for revisiting the legal framework to encourage arbitration and reforms in the existing government-run institution as it has not performed very well. And he also lamented that India lacks proper institutions to hold arbitration proceedings.
I believe in China there are more than 300 institutions that offer arbitral services. In India we have just about one. That too, from the Court of India, it is struggling to find its feet. The ICADR was established some 20 years back at a huge investment made by the Government of India. That institution handled over a period of 20 years just about 20 cases, which is a very, very dismal performance, if I may say, with great respect to those who were handling the affairs of that institute. But then, apart from ICADR, there are a handful of them, a few other institutions, maybe in private sector. One of them has recently come up in Bombay, and one or two other institutions. The result is that arbitrations today are being conducted by the arbitrators and by the litigant public in five-star hotels, sometimes in some clubs.
Well, to discuss making India a global arbitration hub, we have with us in the studio Mr. Ved Jain, is the Vice President of ASSOCHAM and an arbitration advocate as well, and Mr. Sangram Patnaik is an advocate of the Supreme Court and an arbitrator at the Indian Council for Arbitration. Thank you very much, gentlemen, for being with us. Mr. Jain, let's start with you. How closely related is economic growth with, you know, an alternative dispute resolution system that functions?
See, the two things are very, very important to be understood before we answer this question. When we are talking of ease of doing business and making India as a hub, and we want to promote India as one of the places for this, we need to find out the bottleneck which we are having in the Indian economy.
Okay.
I believe each one of us will agree that the judicial system as on date, particularly on commercial side, takes too much time getting a dispute resolved. When businesses are being done despite best of intention at a stage when the agreement is being entered into, there is bound to be some dispute or differences about the clauses implementation as quickly as possible. As quickly as possible.
Okay.
And there,
Okay.
and there are two ways how that dispute can be resolved. One is the normal litigation which happens to the civil court. You file a petition before a district court or before a lower judge.
Right, right.
Go to the High Court and the Supreme Court. It takes years and years and years.
Sure.
The alternative mechanism, world over, is to go for an arbitration.
Yes.
And when we go for arbitration, the arbitration should be speeded up and should be delivered, and the judgment should come very fast.
Okay.
But unfortunately, in India also, though we have an arbitration law, but that arbitration also got stuck up because of the various issues which came up.
Okay.
Because the stay, interim orders, or processes, and court intervention also that were issue.
Okay.
So there has been a concern that we need to have an institutional arbitration.
I see.
And when we say institutional arbitration, meaning thereby there is an institution, and in each of the agreement which are being entered into, it is provided that in case there is a dispute between these two parties,
Okay.
the matter will travel to the particular institution.
Okay.
The institution which the Honorable Chief Justice was referring to, additional or what we call alternative dispute resolution, which
Okay.
a new campus has come up recently. So that's an objective to achieve that objective.
Okay,
Now,
fair
but
enough.
in that regard also it is very important
Yes.
to find out a difference that when a person goes for arbitration vis-a-vis the normal litigation,
Okay.
he reposes full confidence in those arbitrators. So that
Okay.
is very, very important.
So you have mentioned the need for arbitration, and perhaps that also answers the question about how, you know, for economic growth to take place, we need to have quick dispute resolutions. But the point is that, Mr. Patnaik, is that, okay, the parties have decided that they need their dispute resolved quickly, so they go in for arbitration. But should the courts intervene in the final judgment?
See, according to me, as a lawyer practicing in the court, interventions of late are absolutely not called for. Number one. Number two, Petition and Conciliation Act, when he is being agreed by the award on three grounds basically. But to say that no, you do not have a defense at all after the award is passed, this is too much to ask for. But certainly, this is a step in the right direction, undoubtedly.
Okay.
First is the amendment in the Arbitration Act in December 2015, particularly Section 29,
Right.
where it says that yes, it has to be over within a certain period, and after that the consent of the parties. And the third, the last 6 months, is to be taken by, or given by the court. So
Okay.
therefore, you have a period where you have to perform,
Okay.
both for the lawyers, both for the arbitrators as well.
Right.
So earlier it used to, go on for years, even arbitration also. And, as a lawyer practicing or as an arbitrator myself in the ICA,
Yes.
at times I feel where we are lacking, because particularly when your parties, the clients, they prefer SIAC, Singapore International Arbitration,
right.
or the Paris, for example. Why do they go to that place?
Why do they go there?
If it is available here,
Sure.
and with a similar standard,
Right.
right? So therefore, I would suggest this is one of the best steps that has been taken. One.
Okay,
Number
fair
two,
enough.
the limitation period is after that amendment. Yes, we are confining ourselves to that 2 years period, 1 year, 6 months and 6 months maximum.
Okay. Fair
And the
enough.
challenging part of Section 34, which you rightly said, that of course, one litigant cannot be remediless, right? But that doesn't mean that yes, every hour needs to be challenged, right up to the Supreme Court. Here we have a system where you challenge it in 34 in the respective High Court, then the appellate, then the Supreme Court.
Okay.
So in any case, the moment you challenge, it goes right up to the Supreme Court.
Right.
So that has to be curtailed down, according
It
to me.
has to be curtailed. So, Mr. Jain, you talked about institutionalizing. Now, the point is that, some could argue that it's better without an institution, because, the two parties, they decide who they want as the arbitrator, the neutral arbitrator to judge these things. There are places you can go to, sit down and discuss this issue and sort it out. It's supposed to be out of court, out of an institution in a sense. You know, I mean, the whole concept of alternative is, should it be institutionalized? That's making it like a court.
I see why institutionally is important, You see, when at the stage the agreement is being entered into, an arbitration clause is being introduced, nobody is having doubt or a bias against each other. They are both want that in case the dispute arises, it should be settled very quickly. And then they provide that in case the dispute arises, let us go to that institution. Why other countries popular? Why other countries these are popular? These are popular because those institutions has created a faith amongst the various industry and the business. Yes, in case you have a dispute and you come to us, will be fair, unbiased, and we will be giving a quick disposal on that issue. That's what the issue is. And that is very important that India, when we say that yes, India needs to come up with this type of institution should create a faith, among the industries, among the people. Yes, you please put a clause in your agreement that in case the dispute arises, we will go to this institution.
Let's take this question to Mr. Patnaik also, because let me just frame it a little bit, because you see there, the Prime Minister said there's no dearth of talent. And there are lots of judges, there are a lot of, you know, engineers, scientists, anybody, a lot of people can become arbitrators, but should they all be coming into a formal institutionalized process, or can they function independently?
See, I'll tell you, there are two ways to look at it. One, the moment it is institutionalized, what happens is that, like as a lawyer, you go to the court at 10:30.
Right.
Similarly to the arbitration, you reach at the time and then you attend as a special arbitration lawyer or as an arbitrator. You have no other things to do. As on date, what is happening? The reality of life we must face. That with great respect to the judges, retired judges, and the arbitrators, lawyers, everyone, to my own community also.
Right.
Like we think in terms of that. No. It is secondary. 3 o'clock, 4 o'clock after court hours, we are going to start this arbitration.
Right.
Suppose it is 10 o'clock, sir. Like you go to the court, be that as whatever manner you go to the attend to the court. So similarly, 10 o'clock you are there in the arbitration. Like why this Singapore is evolved as a good arbitration center is this, that there is a time period. 2 days is fixed for the hearing. You cannot have any excuses, no adjournments. Readings are complete. Argue and finish it up. That's how we should look at it. The moment you are at an institution, you think that yes, within 6 months period it has to be over. Otherwise, even the arbitration, this amendment, it says that the arbitrator fees also be to reduce down. So nobody would like to take that chance.
Fair enough. We have to take a short commercial break at this point in time, but there's a lot more to discuss. Do stay with us. You're watching India First. We are discussing prioritizing arbitration and trying to make India an arbitration hub. Stay with us.
बचपन में पेड़ चढ़ना अच्छा लगता था। बड़ी हुई तो सब चाहते थे कॉर्पोरेट लैडर चढ़ जाऊं। कुर्सी पर बैठे इनविजिबल सीढ़ियां चढ़ना नॉट माय स्टाइल। मुझे पसंद है टेक्नोलॉजी और पहाड़ चढ़ना। एंड दिस इज द ओनली जॉब जो मुझे दोनों करने देता है। इट्स लोनली एट द टॉप, बट द व्यू इट्स इनक्रेडिबल।
हम है भारत के सबसे एक्साइटिंग वर्कप्लेस और हम दे रहे हैं आपको एक ऑफर। भारतीय सेना, आम नहीं ये जिंदगी।
नहीं यार, अब ये रैगिंग बिल्कुल बर्दाश्त नहीं हो रही है। कंप्लेन तो करनी पड़ेगी।
तू पागल है कोई ये क्या? सीनियर से पंगा लेगी तो तेरा और बुरा हाल करेंगे।
नो यार, हेल्पलाइन नंबर है, आई एम श्योर दे विल हेल्प।
हेल्पलाइन नंबर से कभी किसी को हेल्प नहीं मिलती।
एटलीस्ट वी शुड ट्राई।
आपकी थोड़ी सी हिम्मत और एक कंप्लेन की वजह से आपको रैगिंग जैसी बीमारी से छुटकारा मिल सकता है। यूज हेल्पलाइन, इट हेल्प्स।
अब ना होगा केवाईसी का झंझट और ना मार्जिन पेमेंट का।
सर आपका क्या?
और भाभी जी कैसी हैं? वहाँ मायके में है, ठीक ही रहती है वहाँ। और टैक्स भी नहीं देना पड़ेगा और ना हमारा नाम कहीं पे आएगा। इसे कहते हैं डब्बा ट्रेडिंग। इसी को कहते हैं
डब्बा गुल, क्योंकि ताली कभी एक हाथ से नहीं बजती, इसलिए डब्बा ट्रेडिंग करना या करवाना दोनों ही कानूनन अपराध हैं। सिर्फ सेबी रिकॉग्नाइज्ड स्टॉक एक्सचेंज पे ही ट्रेडिंग कीजिए। सेबी, हर इन्वेस्टर की ताकत।
बच्चन जी।
बोलिए बच्चा जी।
आपने वो फिल्म जादूगर की थी ना?
हाँ की थी।
तो मुझे जादू दिखाइए।
अच्छा। ये देखो मैं यहाँ पत्थर मारूंगा, यहाँ से कबूतर चिड़िया सब निकलेंगे। वो गया देखो, कबूतर चिड़िया सब उड़ गए।
बच्चन जी।
हाँ जी।
बस इतना ही?
हाँ और क्या?
अब मेरा जादू देखिए, ये वाला पत्थर वहाँ मारूंगा और इंसान निकलेंगे।
इंसान?
हाँ इंसान। देखो।
अरे कौन है भाई?
देखो।
अरे यार क्यों तुम लोग गांव की इज्जत पे धब्बा लगा रहे हो? बाहर से लोग आएंगे तो क्या सोचेंगे? स्वच्छ भारत अभियान के अंतर्गत भारत सरकार जो है वो शौचालय बनाने में मदद कर रही है, तो आप भी अपने घर में शौचालय बनाइए, परिवार को उसका इस्तेमाल करवाइए। अच्छा मेरी नहीं सुनते हैं तो कम से कम ये समझदार आदमी की तो सुन लीजिए।
Welcome back. You're watching India First. We have with us in the studio Mr. Ved Jain, Vice President of ASSOCHAM and arbitration advocate, and Sangram Patnaik, advocate of the Supreme Court and arbitrator at the Indian Council for Arbitration. And we are discussing making India a global arbitration hub. Mr. Jain, before the break, you were advocating, that we should institutionalize the entire process, because obviously you in your first answer you talked about quick resolution. Parties need this. But, for this entire process to take place, do we need to have specialization in arbitration?
See, there is nothing. See, question
There's no
is
such
not,
thing as specialization.
Question is the experience being as a judge or an advocate itself is I will say, a specialization. As far as I see in India, there is no dearth in the talent. We have experienced judges, we have the experienced advocates, and which have been, I believe, those have been quite good, and they have performed very well. That's not an issue. You see, what we need to address the issue in arbitration is the very most important from a perspective of the people who are going to use. There are two persons who are having some dispute, they are going to use this platform. There are two options available, one is the normal litigation, another is the arbitration. And in arbitration, we need to appreciate this point. The moment they opt for arbitration, they are foreclosing all their other options, and they are agreeing that whatever the decision this arbitration panel will give or arbitrator will give will be binding on both of them. Okay. So meaning thereby they are reposing a faith like a god, sure, that you are the people who are going to do it. So the issue lies is, one is the infrastructure, one is the speed, but the most important and the crucial issue for any person will be the confidence he reposes in those two, the person arbitrator.
Okay, fair enough.
That is why institutionalized arbitration will mean that arbitrators are to be appointed not by the party that he is my arbitrator. You will say that that institution will appoint, and that institution must have an independent, unbiased list of the experienced people, that they will go with that perception, which perception is being today held by the Singapore or the Paris people. Yes, this is the type of arbitration. That's a very important issue.
Right. So, Mr. Patnaik, I mean, Singapore and Paris and all that is being quoted several times, and we heard the Chief Justice also saying that China has more than 300 institutions and we don't have too many. But the point is, who makes a better arbitrator? Should it be somebody who is from the judicial background, or can it be, as the Prime Minister said, that, good engineers, good scientists, all these people can make good arbitrators? After all, in the contract, for instance, I mean, it's not only the legal aspects that have to be, that can be in dispute. There are technical aspects that can be in dispute where, an engineer can probably resolve it better.
I'm entirely in agreement with you. For the simple reason is this, a maritime insurance matter can only be handled by that expert. See, when it is a panel, of course, you cannot ignore the judiciary, right? The approach or the bent of mind of a judge, retired judge, or of a lawyer would be of, the principle of natural justice. Nobody should be condemned without being heard. All those things are known to this gentleman who is, spent almost about 20-30 years in the profession. But you cannot certainly say that, the bridge has to be built, or a maritime matter, or an insurance matter, for example, that needs to be an expert. That is, like, I can only say this, expert, when he adjudicates the issue, he knows in and out of it. And you cannot say, no, everything would refer to the judiciary or the retired judges or the lawyers who can adjudicate everything. Experience is one thing, no doubt about it.
Right.
But experience in a particular field where you would have that comprehensive ability to understand within no moment, and you would put that question that yes, this is what we would like to know, is always come from
So an institution then, Mr. Patnaik, will have to have all these kind of people in them.
Very true.
Who can be arbitrators, and they will choose the panel based on the kind of case that comes forward.
Otherwise it would be failure, right?
Sure, right. Mr. Jain, we live in the digital age, and the Prime Minister there mentioned about, you know, the digital India and bridging the digital divide. Also, startups, new companies, you know, I mean, many of us just click on things and we are agreeing to some contract online which we haven't really perfectly read, and probably they have an arbitration clause in that, you know. So there is a significant need for arbitration in, I mean, when we look at the way the digital world has changed the way we function.
See, there can't be any two opinions on this issue. See, that when we are living in a digital world, and when we are doing so many things, and we are signing off without knowing the implications. And that's why there's a need, as the Prime Minister rightly pointed out, there's a need to create awareness. Now see, this type of program which has been conducted recently and the earlier program being conducted, there's a need to sensitize, yes, we do have a system which is comprehensive, which has best of infrastructure, best of talent, and you can look into this. So this will promote, and I can make a beginning. So how it can be made a beginning? Now we have a large number of public sector undertakings. Now those undertakings, whenever they enter into an agreement, they can put a clause, yes, in my agreement, the arbitration has to be done by the ADR. This is right, which you are talking about it. Similarly, awareness can be created within the various chambers, that when your people, when your members enter into various agreements, they should look into the ADR and to work it out with the ADR. Similarly, individual, wherever the options are available, sometimes the options are not available because the person who's asking you to enter into an agreement, he says no, arbitration has to be in this manner. But in case both parties are at par and both parties can play a role, yes, the Indian can play a role, can know this arbitration has to be done in accordance with the ADR.
Mr. Patnaik, are Indian companies at a disadvantage then when they're entering into contracts where, you know, they agree that dispute resolution has to be through arbitration, and, you know, the company, let's say if you're entering into a contract with a foreign company and they say that no, it has to be Singapore, it has to be Paris or whatever, you know, are Indian companies then at a disadvantage?
See, I'll tell you, you know, even you know, most of the Indian companies, they opt for SEAT or Paris or London for that matter, with their own choice and volition. It's not that somebody is going to force upon them to have an independent place of arbitration like this nature. No. But given a chance, if it is available next door, suppose if you are a company of immense stature based in India, you would not opt to go to London and hire a British solicitor and to engage him and pay that hefty fees.
Exactly.
You would have everything here so that, you know, tomorrow when there is arbitration clause, see, at the time of entering into the arbitration, right, that clause, you have to force upon that, yes, the place of arbitration would be this, the law govern the contract would be Indian. So then you would say that, yes, please come to this place.
Are costs an important factor then, Mr. Jain, that, you know, can bring arbitration to India? Because, well, I mean, people would obviously not want to spend so much money in resolving a dispute as, you know, if they can get the same kind of resolution in a country which can offer the same services but at lesser cost.
I will say definitely cost is a very, very important factor. And we all know how expensive the arbitration is in Singapore, London and Paris also. So cost is important, and for that purpose, as a chamber, what I will say is the way we have promoted medical tourism. Now so many people come to India for treatment. Why don't we promote India as a what we call that arbitral tourism? So for that purpose also the many people can opt for this India as a center. But so far as the question of entering into an agreement and working it out arbitration in India, we need to be conscious of one fact. The bias of the countries also plays an important part. So many times when international agreements are being entered into, both parties agree to have an arbitration in a neutral country with a neutral arbitrators. So that's also one of the issue. It is not important, it's not necessary. So if I am an Indian and I enter into an agreement with a person, gentleman in London, so we both may agree, no, we will not go to London, we will not go to India, we will go to Singapore or Paris, and arbitrator will be non-Indian and
so India is neutral for many companies across the world
important because you need to remove the bias wherever it is occurring. But at the same time, looking to the fact that India has an English language, we have talented people, talented judges, talented advocates at a much effective cost. we need to encourage and promote what we call legal tourism, and this can help India bringing a lot of revenue and also reducing the cost for the Indian people also.
One final question, Mr. Patnaik. You know, the President, while he was talking about institutions, creating institutions, also referred to some sort of ad hoc arbitration taking place, which is quite a lot. That's what the arbitration that's going on in our country. It's ad hoc, and it's probably been going on for a long time. Now the laws have been changed. The institutions are being built. What is the potential? What do you think is the road ahead?
See, my take is the era has come. We cannot ignore the arbitration as a concept in any contractual agreements, particularly national or international, number one. Number two, this ad hocism, like a moment before I was pointing out, that 3 o'clock arbitration, after your court work is over, that you are free, so you would say that yes, 3 o'clock I can reach. The arbitrator would give you the time at 3 o'clock. That should not be. The ad hocism, the attitude towards arbitration should be that yes, I am a specialized lawyer, I am a specialized judge, I must be available 10 o'clock, and it should be for 2 days, it should be over within the time. Then only the confidence of everyone, be that Indian, be that the foreigner or the foreign entity or the MNCs, that confidence will be built. Today, if you see the data, then probably number of them opt for the outside, even the Indian companies. Why? Number one, it is not available. Second, is a lengthy procedure. Third, in every step, it is being challenged. So what else? Like, suppose, you would say that this is the arbitration center, I have to reach there, I have to practice there as a lawyer, and then it should be adjudicated in a specific time. So thereafter,
specific time, and the award also has to be respected by both parties, which is at the end of the day the most important thing. We leave it there. Thank you very much, gentlemen, for being with us. Well, the Prime Minister summed up India's opportunities as an arbitration center by saying that corporates and financial institutions want legal experts who can help close business deals and transactions without any disputes and litigations. They also want to resolve disputes quickly through arbitration without going to the courts. India has no dearth of brilliant lawyers and judges, and a large number of retired judges, engineers and scientists who can function as competent arbitrators in various fields. Well, India's economic interests shall be better served by a higher number of arbitration experts and lawyers. Thanks very much for watching. Namaskar.